SJC-12917, Sharon Heath-Latson v. Alexander Styller.
And we'll hear from Mr. Leontire, please. You have to unmute yourself after I ask you to mute yourself.
Okay, how's that?
Great, thank you.
Thank you. Good morning, Your Honor. Good morning, Justices. My name is George Leontire, and I represent Sharon Heath as personal representative of the estate of Kevin Heath. And Mr. Heath, as I know the court is aware, Kevin Heath was murdered at the party that took place at the Styller residence. I know this is a complicated issue, and I know it has lots of ramifications. I would like to explain that the basis of the trial court's decision was that in a residential landlord and tenant relationship, unlawful acts of third persons are not deemed to be a duty or foreseeable. And that is a true statement of residential landlord and tenant law. However, that is not what we have here.
But that's a kind of an oversimplification of what the motion judge did, didn't he? He's applying appeals court precedent, Belazar versus Furr,
Right.
That where they actually don't even need to decide whether there's a tenancy or at least a formal tenancy, but just that the harm is not foreseeable. And I have real trouble understanding how the harm to your client is foreseeable from this Airbnb rental agreement. I can understand if you rented your apartment in a very dangerous area with bad locks on it, and then somebody gets attacked inside the apartment. That might be one thing, but I don't understand how renting your place out for a college reunion it's foreseeable that someone's going to get murdered there.
Mm-hmm. Well, first,
tell me how there's a duty owed to your client here.
Sure. First of all, this wasn't a college reunion. None of the people who rented the place went to college. Secondly, Mr. Styller put a limit, and based on the record, at different points, he said it was 15 people, 20 people. But the fact of the matter is, the day that this took place, the event took place, he was there before it started. He saw that there were multiple bars, DJs, lots of people, and he knew that this was going to be a major event. Not only was it, as was referred to in the earlier session,
but again, how is even a major event?
Mm-hmm.
Again, it's a murder. I understand if you're suing the person who killed your client, mm-hmm. or if you're even maybe suing Mr. Victor because he misled Mr. Styller. Mm-hmm. But how do you get a duty of care from Mr. Styller to your client?
Well, Your Honor, there are areas where we do recognize that duty of care, and I don't think this is much different. For example, in the hotel guest situation, in the college situation, where there's an assumption of the duty, and here Mr. Styller, under the terms of the agreement, the Airbnb or related type agreement, acknowledged that he was assuming the obligation for security.
He was renting out a house that had safe security in case burglars. You rent out a place, you want to make sure that someone can't walk in. Mm-hmm. But I don't understand. Again, we have to look at the foreseeability of the harm here, and also the you're merging a bunch of different concepts. Your client and Mr. Styller are, really, I just don't see the connection here that Mr. Styller could foresee harm to your client, foresee your client being shot by somebody. by
Is it
renting
not?
out his place.
In today's world and custom and usage, all across this country, in Airbnbs, where these kinds of parties are taking place, people are being murdered. It's not foreseeable that in a situation where it's not regulated and you have several hundred people present in a residential neighborhood with no controls on health and safety, or with and liquor being applied, that a situation and an occurrence like this, in fact, is possible. I would beg to differ that that this is not a foreseeable event. Not only is it
Well,
foreseeable,
Counsel, there's a difference between possibility and foreseeability. You said it's possible, but surely we're not at the place yet where just having a large party portends murder.
I think that it's foreseeable that it's possible, Judge, honestly.
Foreseeable that it's
Well,
possible.
And
well,
I
you
don't
know, I
think-
can understand it if the harm were if the person died by, say, drowning, or somebody was killed as a result of the drunken behavior at the party, that we might have something that would be foreseeable. But how could you foresee that somebody's going to get shot at this party? That's the question I have. How could you foresee that?
Well, you foresee it, number one, by not allowing 180 people more at your residence.
But how do you foresee murder? How do you foresee murder in that area by shooting? I could see other kinds of injury. I just can't see that.
Well, Judge, I think that in lots of communities in this country, people do see it and are concerned about it.
Well, not in Linfield.
Well, a lot of those people who went to that party, most of them were not from Linfield. And so I think that that when someone goes to a party of that magnitude, advertised on the internet, all are welcome, and the owner of the property fails to, when he realizes what's going on, fails to take any action whatsoever and walks away.
What did he realize was going on in your view? What is the fact established in your view?
The use was supposed to be a small number of people for a college reunion. He shows up in the morning that the event is supposed to take place, sees lots of people there, several bars.
How many people does he see? How many people does he see?
I'd have to go back into the record, Judge. I don't remember the exact number, but it was
Hundreds of people he sees. Hundreds of people. He's saying he doesn't see. He had hundreds of people, right?
no. He did not see hundreds of people at that point, but he knew
Okay,
that.
so he never. When he left, the most he'd seen is what? A dozen people.
It was more than a dozen because they had bars set up. They had music, DJs.
So Counsel, is it fair to say you don't really know?
I don't remember off the record exactly how many there were, Your Honor.
Can I take the Airbnb part of this case out of it? So, you know, that's a relatively new phenomena that we just discussed in the last case. But if you had, you know, throughout our jurisprudence, if you had parents whose kids had large parties and there was unfortunately a murder or serious physical violence, or any other landowner who had a party and there was physical violence to another, don't we have lots of cases that deal with that, and whether or not there's a duty of care in those instances, and completely take Airbnb out of it?
Well, I don't think you can take, I agree. In that situation, I'm not arguing in that situation. I'm arguing in a very defined situation where
Okay.
there's
So
no control over the situation.
right. So suppose that I go away for the weekend and my 20-year-old kids are home and they have a huge party, and I know they're going to have a huge party. I say, have a good time at the party, and there's violence at the party. Isn't that the same situation?
No.
Why not?
Because it's not. There's, in one, you have clearly a family, parents, kids living in a home. Another, you have people showing up for a couple of days, and you have an owner who's renting out for commercial purposes, and does not even live by the agreement of what was supposed to take place at that commercial activity. And I think you can distinguish, by the way, this is where I think we've gone awry here. This was not a simple residential party. This was a commercial activity that Styller was allowing to take place on his property. And there is a distinction between, in lots of commercial situations, we require health and safety. We require police to attend. So this is not some social host party. This was an intentional commercial rental that Styller failed to minimally make sure that the people who were using it were going to use it in a safe manner.
But where does that jive with the Pine Manor type analysis in the special duties of care that you argued? I would imagine that if I go away for the weekend and my irresponsible 20-year-olds have a party, it's some special duty of care, as opposed to if I rent my house to a family and they have a party that goes awry. So what does that special duty of care fit into this analysis?
Well, in Pine Manor, the court discussed that the college's duty exists in the social values and customs of society, and also that the college voluntarily assumed a duty to protect residents. I think that Styller, who was renting out for commercial purposes and was the only one who could control what was taking place at his property, owed that same duty.
I think Justice Lowy has a question, but he was muted. Hold on.
Thank you, Justice Gaziano. Are you trying to prove too much just by the nature of the commercial use? Wouldn't a better argument, we'll ask Mr. Sullivan about it, be that this is a negligent entrustment situation when the defendant goes back to the property and actually sees what's going on, and at that very moment, nonetheless, he entrusts the property to what is impending?
Yeah, I agree with that 100%, Judge, and I think we made that argument where we talk about negligence per se, and I understand the argument, and I agree that that's a good argument. I'm appalled at what Mr. Styller did here.
Yeah, but I think the reason I asked is because I think that Justice Lincoln and Justice Seifel were trying to get at some facts that might support that. Because if that's a more narrow theory of liability, then what are the facts here as to what he saw? You've mentioned that there were a few bars set up and that there were some unknown amount of people.
Yes, Judge. And they were setting up the music system, which was a very large music system. It was from the facts, it was my understanding that it was clear to Mr. Styller, and I believe it's in the record, that this was going to be a large event, a large party.
Mr. Lantire, what is your client, was he an invitee to this? Is that in the, I don't even, from what I understand, the invitation to this was, you got to be invited or you've got to be a girl. That was that was the invite to the party. I take it your client's not a girl, so was he an invitee to this?
Yes. The fact is that,
and that's alleged in the complaint, that he was invited by Mr. Victor to this party?
he wasn't invited by Mr. Victor, nor did they operate that way, nor did they operate by just letting women. What they did was they put it out on the internet, and lots of people, it would be one person that was invited, inviting other people. One of the things we talk about and allege in the complaint is that they didn't check anybody who was coming in the door, whether they in fact were invited or not.
And did you sue Mr. Victor?
We did.
You did? Is that right?
Yes.
Okay.
What's the status of that case, the case against Mr. Victor?
They filed a motion motion for summary judgment in that case. They're alleging that Mr. Victor was doing other individuals a favor by using his credit card to pay the $7,500, I believe the amount was. In deposition testimony of the other individuals, they claim that Mr. Victor is the only one that has any asset. Here's an insurance policy, a small one, but there's an insurance policy. And the other individuals that rented the place have no assets whatsoever. We've done depositions, etc.
Thank you.
Any further questions, counsel? Thank you. We'll turn to Mr. Sullivan, please.
Thank you.
Good morning, Justices. Chris Sullivan. May it please the court, on behalf of Mr. Alex Styller. The general rule in the Commonwealth of Massachusetts has been that a landowner does not owe a duty to guests for the random violent acts of a third party. And that has been the policy of this court, and it's been part of our jurisprudence in the Commonwealth of Massachusetts for a number of years. And there's good reasons for that. And the reasons are that, one, fundamental fairness. A landowner, if the landowner is going to be held accountable, should be aware of what the landowner will be held accountable for. Secondly, it's also part of our negligence statutory scheme and our case law, where in order for someone to be held responsible, to be found negligent, there must be a duty and there must be causation. The third part is that it creates an incentive for landowners to keep their property safe, to try to maintain it in a good manner, in a safe manner, because the alternative is that if there's not that incentive, if it's almost a strict liability analysis where if an accident happens or there's violence on an individual's property, you're automatically or strictly liable, there's really no incentive for a property owner to want to keep their property in a good condition.
Mr. Sullivan, can I focus you a little? And I get the basic parts of this. I'm just trying to test the limits of it. So Mr. Styller is running a business out of his house, essentially, sort of a little bit of a party business. He's informed that that he sees the party isn't a little college reunion, but it looks like it's gonna be a real big party. I mean, yeah, if you're a bar owner and you're running a nightclub, you've got to have bouncers and security and stuff like that. I'm just trying to get a sense of, if you're running a giant party for commercial purposes, you tend to have some kind of security present. I guess that's where I'm thinking, is this starting to border on, if you're running a commercial party, a large one, forget about where it is. Mayhem is a possibility. Shooting may not be, but this is a big internet party for commercial purposes. And your client has some sense that it's going to be a big party at this place, right? How do you deal with that? This isn't like I rented my house to somebody and some stranger got shot there. I rented my house because I knew my house is a big party place, and I turned it into a commercial operation. I don't mean to oversimplify, but that's at the outer edge of this. That's what we've got here, right?
Well, the facts are that at 2 p.m. on the day of the shooting, and keep in mind the shooting wasn't until 3 a.m. The following day. Right. At 2 p.m., Mr. Styller comes to the property, and he does not see anything that's going to alert him to any type of potential violence or danger. And what does he see? He's walking around the house. He's showing the different appliances. He's showing the guests, or Mr. Victor, how to use the pool. There's nothing, and I disagree with.
But tell me what's. I thought there were a bunch of sort of young women in swimsuits. There's also bars being set up. Is that what does he see at 2 p.m.?
From what we can tell, that's been pled in the complaint. He sees that there is more than 15 people that are present and that there was preparations for a party, but nothing more. Nothing else has been alleged.
What in the, like, bar, bars set up, multiple bars set up? How many DJs does he see? I'm just trying to get a sense of what he sees at 2 p.m.
And in the complaint, there's no specific allegation of how many disc jockeys are there or any of the other specifics other than that there was a preparation for a party. So there's no specifics as to how many bars, how many disc jockeys. But the real issue in this case, in determining whether or not Mr. Styller was really running a commercial business, is this is really something that was incidental. I mean, that's a single family residence. He is earning some supplemental income by renting it out. And the question really is whether or not in this instance, does he have any indication that if there's going to be any type of violence or any type of a crime from what he sees? And at 2 p.m., he sees nothing that's going to give a reasonable landowner notice that there's going to be any type of a crime or any type of violence.
So at 2 p.m., he doesn't have a sense that his house is going to be turned into basically a nightclub with 100 people running around. Is that, when we look at that complaint, and again, we've got to assume all the facts are true in it. There's no indication that basically his home is being turned into a giant party.
I would think not at 2 p.m. And keep in mind that Mr. Victor said that he was going to throw a party. He's going to throw a college reunion party. So that really wasn't something that would alert Mr. Styller to something that was completely different from what the understanding was when he rented the property. His understanding was there was going to be a college reunion party. And the fact that it's a large party doesn't really rise to the level of alerting someone to the use of firearms, to the use of violence, to the fact that a murder is going to take place. There's not enough in that brief visit when he's basically walking through the house and showing how the appliances work and how the pool works that would in any way rise to the level, for instance, in Bella's.
But Mr. Sullivan, what's the rule of law, though? So as Justice Slink asked Mr. Leontire, if someone had drowned in the pool, duty of care?
I would think if somebody drowned in the pool, that yes, you could see that there was a duty of
All right,
care.
so, and then we have some women there in bathing suits. We have food put out. We have DJs and lots of liquor. If there was a sexual assault, is that foreseeable? Duty of care?
I would say no for a sexual assault, no, because there would have to be some indication to Mr. Styller previously when he rented the property out that there was some type of violence that took place. And keep in mind, and all the other
a bar fight by two liquored up young people, would that be coverable? Duty of care there?
I think that it's potentially recoverable, but I think on these facts there's not any evidence that.
So what's if we have to write this case? What's the legal reason we use to distinguish between the person who drowns in the pool or a bar fight versus this incidence of third-party violence?
Well, is there a special relationship that has been created between Mr. Heath, who we have no idea what his relationship is with Mr. Victor, what his relationship is with Mr. Styller? Nothing's pled in the complaint. We don't know anything about the shooter. Nothing was alleged in the complaint. His relationship with Mr. Styller, his relationship with Mr. Victor, we have none of that information. And that's part of the problem, is that unlike, say, in the case of Belizaire versus Fewer, which is very similar facts here, there was 50 people present. And in that case, the plaintiff actually had to pay to come into the party. Liquor was being served, and an unknown third party pulled out a gun and shot the plaintiff for apparently no reason. Very similar set of facts. And this court found that there was not enough evidence to put the landowner on notice of his duty of a potential violence from a third party to the guests. And that case, I think, is really controlling here, because in that case, even though there was some prior history of criminal activity, low level, even that was not enough to create and bring to the level of a duty that was being owed. Here, there's even less. We have Mr. Styller, to some extent, being duped by Mr. Victor, who said, I'm having a college reunion party. And so he rented the property based upon that representation. He showed up at 2 o'clock and didn't see any evidence of violence or anyone fighting, any disturbances. The police were called at approximately 7 p.m. And when they came to the property, they asked people to move some cars around, but that was it. And those are trained professionals who are there to detect crime, detect potential violence. They found nothing amiss at 7 p.m. and they walked away. The people who responded at the house were compliant. They were cooperative. There was no issues. There was nothing the police had to do. They left at 7 p.m. and now at 3 a.m., there is an unexplained shooting where Mr. Heath, for whatever reason, is shot by some unknown criminal assailant. And absent a special relationship, that general rule of a landowner not owing a duty to guess on the property without some evidence of either a special relationship, or the other exception is, did the landowner know or should the landowner have known? And in this case, I think we can all agree that there's nothing even alleged in the complaint that Mr. Styller knew of the propensity for violence. He had rented this property out numerous times beforehand without incident, no calls to the police, no violence, no shootings, no guns, nothing at all.
Mr. Sullivan, is there any any allegation that Mr. Styller knew this was being publicly advertised on the internet as a party?
Absolutely none. There's nothing alleged in the complaint, and there's no evidence at all. Mr. Styller was with his family so many miles away from the house when either when the police were called, because he had no knowledge of it, they simply reported to the property. They didn't contact him. And then he was miles away from the property at 3 a.m. when the shooting took place. And those special relationship cases that the court touched upon in asking questions of opposing counsel are important. I mean, Mullins versus Pine Manor talked about the relationship between a college student and a university. Very different relationship. There's an expectation that when a family and a student is going to college and paying for college, that they're going to be educated, they're going to be housed, and that they're going to be cared for. That's not the relationship here at all. This is a landlord-tenant relationship. Also in Fun versus Lenox Hotel, in that case, there had been a history of criminal activity. The individual, a plaintiff who was staying there, her room was right next to a fire escape that had been used for crimes beforehand, and the hotel knew about that. And they did not take sufficient steps to protect their guests. Completely different set of facts.
Mr. Sullivan, if I could ask you, because would you agree, I'm just trying to figure out where the line is and how attenuated this duty can still be with liability. Let's say that your client shows up at 2 o'clock and there's 3 DJs set up, there's 3 bars set up, and there's certainly more people than you would expect at a small college reunion. And one of the individuals at the party gets drunk, leaves the party, and kills somebody out on the road drunk driving. Is there a dram shop action available against your client?
If my client served alcohol to the individual,
just the facts I gave. He sees what's happening at 2 o'clock, sees the emerging party, and then take the facts later on. Some hours later, somebody leaves his house, even though he's not there, he's rented it out, and kills somebody out on the road.
I would say no, because he was not in control of the premises at the time liquor was served to this individual. And that's a critical fact, because it's stipulated, and it's part of the complaint alleged in this case, and this is something that the trial court justice focused on in his opinion, was that it's uncontested that Mr. Victor had exclusive control over the property when it was rented. And that's a critical fact, because if Mr. Styller had been there and had been in control of the party, had seen things starting to develop for whatever reason, then maybe there could be an obligation that he had a duty. But I would also argue too that even if Mr. Styller was there and he was upstairs in his bedroom and reading a book quietly, there would have to be more evidence other than people having a good time, people listening to music, people drinking alcohol, to put him on notice that there was going to be a potential act of violence, that somebody was going to pull a gun and murder somebody literally outside near his pool. If he was even there at that time, there would still have to be some type of indication that there was a potential threat of violence or danger. If there had been a fight between some of the guests, if there had been destruction of property, if people were breaking things, if there was some type of an objective fact that Mr. Styller was aware of and he was present, then he would have an obligation to do something. But even under these facts, from what we can see that's been alleged in the complaint, which is not much, there is really no evidence that would put even Mr. Victor on notice of the fact that there was going to be an act of violence or that there was going to be a murder taking place. And that's part of the problem with this case, and what the trial court looked at when the motion to dismiss was allowed is there's
Thank
no
you, Mr.
evidence.
Sullivan. Thank you. You've answered my question. Thanks.
Do you have any other questions of Mr. Sullivan? All right, thank you, counsel.